Welcome to The Explainer. Today, we're unpacking a pretty intense, high-stakes workplace dilemma that takes a moment of absolute joy and turns it into a terrifying countdown. Just imagine this. You make a life-changing, amazing announcement to your boss only to find yourself holding a termination letter literally 2 weeks later. Your hands are trembling, your livelihood is totally stripped away, and you're just left wondering, wait, what just happened?
Okay, let's dive into this. We're looking at the story of Sarah. She's a really dedicated bakery employee who told her boss she was pregnant. And then, exactly 2 weeks later, she was fired. Boom, gone. So the massive question hanging over this entire scenario, the one we're going to break down today, is incredibly simple. Was this legal?
Section 1. The 14-day countdown. A career destroyed.
And this brilliantly illustrates the sheer shock of the timeline here. Look, for years, Sarah had built a really solid, respected reputation at this bakery. She put in the hard work, right? Then comes day 0. She announces her pregnancy to her boss. Just a completely normal, everyday life event. Yet, fast forward exactly 14 days later, and she is suddenly out the door, terminated. So one life-changing announcement, and literally 2 weeks later, her entire career there is completely destroyed.
Now for Section 2. Coincidence or smokescreen? The employer's alibi.
The employer's official reasoning? It was incredibly cold and really blunt. They claimed Sarah was suddenly, and I quote, unfit for the job. That's it. Unfit. But in employment law, vague phrasing like that, it's a massive red flag. Calling someone unfit rarely holds water without a rock-solid paper trail, especially, and I mean absolutely especially when the timeline is this insanely tight. Now, what's really interesting about this slide is the clash between their narrative and the actual facts. The employer's alibi officially claims she was fired for poor performance. But wait, let's look at the evidence. Sarah had absolutely zero prior warnings. I mean, zilch. There were no write-ups, no performance improvement plans, absolutely no second chances whatsoever. It was just an immediate termination exactly 14 days after she said, hey, I'm pregnant.
Moving to Section 3. The Pregnancy Act Framework, Establishing Motive.
So the crucial point is the application of something called the PDA. The Pregnancy Discrimination Act is this federal law designed specifically to protect employees from workplace discrimination on the basis of pregnancy. This is the absolute governing law for Sarah's scenario. It's basically the legal shield that's supposed to prevent exactly the kind of out-of-the-blue termination we're looking at right now.
And when we apply the PDA to Sarah's case, massive red flags just pop up everywhere. I mean, first off, the suspicious proximity to her pregnancy announcement is highly problematic. When you combine a super tight 14-day timeline with a complete and utter lack of prior performance documentation, well, legally speaking, that combination very often constitutes illegal discrimination. The law looks incredibly closely at sudden poor performance claims that just magically happen to appear right after an employee says they're expecting. It's just way too convenient, right?
Which brings us to Section 4, the final verdict. You be the jury.
The ultimate takeaway here is that legal protections like the PDA exist for a very good reason, but they completely rely on the hard facts of a timeline. So, what is your verdict on this one? Do you think the bakery is guilty of a calculated illegal firing, or is sudden poor performance actually a valid defense here? I want you to act as the jury today. Comment your verdict down below and drop the name of the law if you think it applies. The official legal conclusion drops in exactly 48 hours, so make sure you subscribe to catch the end of this explainer. Let the debate begin.